right, guys, we're back. It's another episode of the Fearless Pursuit of Freedom podcast. Man, that took me so many episodes to get down right, but we're back. Got another great entrepreneur, another business owner, and attorney on the show. And so we've got Sean here out of Dallas market who's going to show us or talk to us about real estate title and real estate law.
Yeah, happy. Thanks for having me, Brandon. I'm looking forward to chatting with you today, just kind of about the title business and what got me into being my own business owner.
It's awesome. So discussed previously, you've been an attorney for 12 years. Now you're in title 6.5 years. What steered you in that direction of real estate law?
Honestly, a lot of it was when I first I went to University of Denver Law School. So I came back to Dallas and worked for a law firm, big law firm downtown, doing a lot of litigation type work. So real property side, product defects, so represented buyers, sellers, represented title companies, represented real estate agents, brokers, lenders, you name it.
Yeah.
And at one point in time, it just became evident to me that I wanted to start my own thing. I wanted to be my own boss. And it took a few years to develop that courage to jump ship from a cush job and start from nothing. So I have a twin brother who's also a partner in the business with me, and then a friend of mine from law school. So we decided about a year before we officially opened to start the planning process, and then called it quits at the job, and then jumped right in and started cold calling to try to drum up some business.
Really? That's interesting. It's interesting how businesses start. I don't know what I envisioned the world of being an attorney, but I didn't envision cold calling, that's for sure.
Well, a lot of that was, you got to start somewhere, right? And so we had no clients when we started. And so it was, you got to get them, and you got to go out on the pavement. So it was meetings every day. It's still a lot of meetings every day and phone calls every day, but it was cold calling and agents and investors and developers and builders and set meetings, and then showing them the value that we could bring. And then now we've been around 6.5 years, and we've been pretty darn successful.
Yeah, that's awesome. That's awesome. So 12 years as an attorney. Okay, so you started the Tiago title 6.5 years ago.
Well, it was right around May of 13.
Okay, so out the gate it was title and law. Oh, okay.
Out the gate, and I've also got a law firm too. So it's the other partner in our title business. He and I have a law firm, a boutique real estate law firm that we also manage and run too at the same time. We started that about right around the same time we started Tiago.
Right. Okay. Cool. Because I assume those can't be. I mean, do you office out of the same building, the two companies?
Yeah, you can. So we've got, for the law firm, it's primarily their Tiago's offices. So, but we have the law firm, and I just run it out of the office that I'm located in. I'm mostly in the Plano office, but I'll rotate between here and Dallas. I'm down there teaching a lot of classes, legal classes every day of the week. So I'll rotate down there, but we run the law firm out of the same office.
Awesome. Okay. So let's get some learning on some knowledge.
Yeah.
So like we discussed before, and as you know, I'm in real estate flipping. I'm now doing rentals, and hopefully Friday I'm closing on a small apartment. And I've kind of steered a little bit away from wholesaling, but like I said, I think I've got a lot of wholesalers and new investors that listen in. So, what could you share? I guess there's a lot to talk about, but as far as from meeting the seller, so contract. So I've always used the Texas Trek 1-4 family contract. Yes. I assume that's the safest way to go. I do know other people that have had their attorneys write up, 1-pagers and 2-pagers. And that I guess that could be a totally different discussion. But from there, I spoke to a lot of attorneys, but they had their different views on wholesaling or assignment of contracts. But from the contract to assignment to close, what are some good rules of thumbs and safety precautions and such?
A lot of it boils down to, as you guys may know, all contracts are freely assignable in Texas. So Part of that is a disclosure requirement. Part of it is the way you advertise as a wholesaler too. We've had some recent changes in the law, but from the time you go into contract, I mean, to touch on your contract question, I mean, at the 1-to-4, the Trek 1-to-4 is fine.
Yeah.
I've 1-page contract, 2-page contract, 3-page contract, 4-page contract, 5-page contract that I've written over the years for investors that investors would use. A lot of the times, my recommendation for the type of contract or which contract that I've prepared is based on their interaction with the seller. You know, if you've got a seller that's going to, take a 5-page contract and get worried about it and read through it and freak out because they think it should be simple, because, at the end of the day, a lot of sellers believe that real property transactions are relatively simple. Sometimes they are.
Yeah.
The Trek contract tends to frighten people sometimes because they get this 8 to 9 page contract and they go, oh my gosh, what on earth is this? I don't understand it. Do I need to get an attorney to review it?
Yeah.
So if that's the case, then we just simplify it. If that's the relationship, hey, why don't you go use this 1-pager, because it still is sufficient. Now, it may not have had as many avenues for a wholesaler or a buyer to back out per se, which is what sometimes the 3 to 4 to 5-page contracts have.
Yeah.
But regardless, let's say you get them under contract. I'm a big proponent of including the and or assigns language on the contract.
Okay.
The purpose of that is for the disclosure. It's, hey, seller, I may assign this contract, which I'm allowed to do, but I may assign this contract. And that way you don't usually have a seller come back and argue, hey, and sue the wholesaler, which I've defended before, and say, well, I didn't know that this person was going to assign the contract. Well, you did. You signed the contract stating and or assigns, and not to mention it was disclosed at least on your side of the closing statement. So you knew about it. I think it's for advertising purposes is where wholesalers tend to get in trouble. And
okay.
they say property for sale at 123 Main Street. So these wholesalers on the last 10, 15 years were 123 property for sale, 123 Main Street. Well, the legislature came out a couple of years back and said, that's deceptive advertising. You can't do it anymore. So you can advertise it, but you have to say assignment contract for sale at 123 Main Street, or equitable interest in the contract for sale at 123 Main Street. So that's where I still see issues come up. I mean, I tend to get on a lot of mailers or new wholesalers in the business will send me their advertisements and say, hey, can you check this one over for me, Sean? Just give it a quick look. And a lot of times it's not compliant, or in my opinion, it risks it can create just some sort of deceptive advertising. So that's where we see a lot of the issues happen with wholesalers.
Yeah.
And as you know, then you have the double close too, which, depending on your assignment fee that you may have, some investors will choose to double close it, which is also fine to do it that way.
Right.
I see more investors wholesale just because you're only paying one side of the closing costs versus two. But you can do both.
Yeah, and I've done both, and it really just depends on how I feel about the seller or buyer.
Right.
And then if I'm working with a new title company, I'll ask them, are we going to do a single-sided or double-sided HUD? So are they going to be able to see that assignment in there? Or, But I even had one company that allowed a double closing with a pass-through closing from the buyer's funds to the seller, having the transactional funding.
Yeah, using basically C's funds to fund AB, right?
Right.
So
yeah.
Yeah, I mean, and that you can do that as well. I mean, there's no prohibition against it. I mean, there are certain title companies, and understandably, because there's risk involved, will say that you can't do that.
Right.
Don't take pass-through funds. You have each transaction has to stand on its own. So A and B has to be able to fund, and B and C has to be able to fund. But
yeah,
it's interesting you bring that up, right? I mean, there's a title company, there's investors. You really need to get to know who your title company is and what they're willing to do and not do, because, depending on the underwriter that they have or that they use, and we've got a couple that we use, because we're not a direct shop. So we're not a law firm or a fee attorney for Lawyers Title or a fee attorney for Chicago Title. So we can write on different underwriters, but it's important to know what your title company is willing to do or not do. It's important to ask those types of questions like you've done. I mean, you've been in the business a long time. What to ask. Are you going to do blindside HUDs or not? What's your disclosure requirement? Do you require the buyer and the seller to acknowledge that it's going to be an assignment, or do you require them to knowledge it's going to be a double close? I mean, those are all important questions to ask a title company
Yeah.
when you're interviewing them, and I think every investor should interview their title company and find out what exactly their process is. I'll get on a lot of these investor groups, my name will get tagged, and then they'll reach out to me and ask me kind of what the process is. And that's the way to do it. You don't jump to a title company and just assume they're going to know how to handle investor transactions, because a lot of them aren't used to it or don't like doing it.
Right. That's interesting, because you say there about disclosing to the seller on assignments. I thought, and I could be wrong in hearing you say that, but I thought that it was now a requirement as of last November to disclose that to the seller that you were assigning that contract.
Yeah, well, you should. That's what I'm saying. I mean, you're supposed to disclose it to them, and you should disclose it. But that doesn't change the fact that all contracts are freely assignable in Texas. That's always been the case.
Yeah. Okay.
You can have always assigned contracts for a very long time. Now it's the disclosure, which, in my opinion, you need to do. I'm all about liability avoidance, right?
Right.
I mean, you can avoid getting yourself in a nasty lawsuit with some bitter seller by disclosing it and not violating any sort of statutory rule. Then you need to do it.
Yeah, understandable. Yeah, same deal. I mean, I haven't been in a lawsuit yet, and I prefer to keep it that way for as long as I can.
You don't want to make attorneys richer. We don't need that.
Yeah, right. Okay, so the way you contract a property kind of is up to you. Either 1 to 4, have an attorney write you a 1 or 5 page or whatever. Disclose and then advertise properly, meaning you're not selling the property; you're selling equitable interest or your paper on that contract. Or
yeah, exactly. Right. I mean, and for those that are on the podcast that may not know, you have equitable interest, which is what Brandon's talking about. You put a property under contract, you have an equitable interest in that property. That's what you're assigning. The seller is the one that has actual legal ownership of the property.
Yeah.
There's the big distinction between the both. But yeah, I mean, as far as advertising, you just have to be sure it's very well known that it's an assignment contract for sale and it's not the property for sale.
Right. Okay. I'm writing down questions as I'm thinking about them.
Yeah.
Because there's a lot of things in my business that I've turned off because of legal concerns. So it'd be interesting to get your input on that.
Sure.
So as far as advertising, okay, so advertising to the seller. So I've got a list of foreclosures. I've always send them direct mail.
Okay.
I was at one point sending mass text and mass ringless voicemails and cold calling. I turned off my cold calling, even though the software that I use scrubbed the DNC list. I was still getting complaints about either they were on it and it didn't show up or whatever. And same deal with texting. It was at least once a week I was getting threatened to be turned into the attorneys generals because I was texting them for some form of advertisement. Yeah. So, and I'm sure there's guidelines for pages, but let's say mass texting. I turned that off because I just got too many threats. What are the guidelines there as far as advertising to sellers?
Well, it really boils down simply to solicitation, right? I mean, if you're soliciting, there's certain, and I won't dive into the statutory rules and because that can get somewhat mundane, but if you're soliciting, certainly if you're soliciting somebody against their will, if they've asked you not to do it, I've always taken the position that cold calling, well, especially now in the last 2 to 3 years, this cold texting and the cold type calling, I mean, that really is solicitation.
Yeah.
I don't know how. I've never myself, paid into any of those lists, so I don't know how they scrub the information. Don't scrub the information. Mailers have always been generally accepted, right? I mean, somebody can take a mailer and throw it in the trash.
Yep.
And if it's disclosed that it's a solicitation or an advertisement, then you're really not encountering any problems. I don't think there's necessarily anything wrong with, like, if you get, let's say you get a number from a prior seller you've worked with. They're like, hey, you should go call my neighbor. Maybe they don't tell the neighbor that you're calling, but you should go call my neighbor and just see if they'll sell their house to you. I don't think there's anything wrong with that.
Yeah.
I think it's these mass lists. Now, again, you got to yourself practice, what's the practical effect, right? I mean, you have the law and then you have the practical side of it. How many of these people are actually going to turn you into the AG? I don't know. I mean, what a lot of, I think, wholesalers do is they just have to gauge their risk tolerance. Are they willing to potentially violate a law at the risk of getting the business? I don't know. I mean, some choose to do it, some don't. I tend to be a little bit more conservative in my approach. Like, I think that your approach is pretty spot on. I think that the text campaigns and the phone calls, I think that's borderline. That is solicitation, and it's getting pretty aggressive. I think, and even emails. I mean, if you read some of the recent cases that have come out, I mean, emails where you've got to put the disclaimer on an email or an unsubscribe button, right?
Yeah.
If there's not an ability to unsubscribe, which text message you can't unsubscribe, or a phone call you can't really unsubscribe, then I think you've clearly got in the realm of, I think you're clearly running a pretty big risk.
Yeah.
But that's to say that people don't do it, because I know it happens.
Yeah, the emails were the first things I turned off because there's actual case law on email solicitation. So I was like, all right, I'm not floating. I'm not going down that river. With cold calling, I think there's still a lot of people skating that gray line because there is no case law that I know of that shows a lawsuit going full bore on the advertiser, the investor. And same thing with Ringo's voicemail. I think there's no case on that either. So people are just RVM all day.
Yeah, I mean, that's like I said, a lot of people do it. I mean, you just look, who wants to be the first? I mean, do you want to be the first case or not? I mean, I don't know. I mean, it's sort of, I kind of look at it like, all these, remote notarization and e-close, this remote online notarization that you can do now, as of July 1st of last year in Texas. And, we're just kind of, no lender wants to be the first one to do it. I mean, we've done cash buyers and sellers, but no lender's ever taken the step, because I just think nobody wants to be the test case. But the emails, I mean, and we still do, like, even at Tiago, we do you might even be part of it. We do a tip of the week where it's legal tips every week, but it's, it's got the subscribe on the bottom. It's got the disclaimer. You can unsubscribe if you want to, and you've got the option, and that was one of the things about the emails that was really, really important. If you can't have an ability to unsubscribe from it, your butt's going to get handed to you.
Yeah, and same deal with the text, right? There's got to be a why or no to opt out type of deal.
Mm-hmm.
Yeah, that's why I've always used the big platforms like MailChimp or I forget the mass texting one, but I used all the ones that did all those proper things. But I still ended up turning it off because I don't want to be that guy. Even though I was a small guy in the area, I don't want to be the guy that gets sued.
Well, no, man, you just get on the wrong side of a seller that maybe he's litigious, and all it takes is one person, and we know we're in a very litigious society these days. So all it takes is one person to get upset, and then you're the test case.
Yeah.
And I'm not saying don't do it. I'm just saying my suggestion to all investors is to just do your homework, evaluate your risk, what's your risk tolerance, evaluate it. And what's the upside? What's the downside? How much are you spending on the service? How much do you stand to make? Again, it's all about risk. And I think that's anything in the wholesale and in the investing world. I mean, we all know about that, right? What's the upside? What's the downside? What's your risk? And if you can answer those, as long as you're asking yourself those questions and you feel good with your answer, then make your decision.
Yeah. Well, maybe I won't, because it might piss off a lot of people. But the wholesalers right now, there's a couple of guys going around teaching new wholesalers to contract at whatever percentage, but don't worry about it if you can't get it sold, because 3 days before closing, you're just going to go in and drop the price. and they plan to do that on every single deal. It's their strategy. Contract, drop 100% of the deals.
Yeah.
I think that's fraud at the core. What are your thoughts on that?
Well, I don't know if it necessarily amounts to, and I haven't seen any cases yet where it amounts to actual fraud. Now, oftentimes we talk about the law and we talk about what's right and wrong and morals and ethics and best business practices. I believe that type of approach is not the best way to conduct the business. And hopefully that doesn't upset anybody, but
it's deceptive.
And we don't really work with many investors that do that, but I don't see it a whole lot. I mean, I've heard of it. Because the other side there too is, I mean, if you do that, then everybody involved, everybody gets sort of thrown on the bus, right? I mean, like if you're dropping the price 3 days before closing and you get this really upset seller, I mean, they're going to blame you as the wholesaler, they're going to blame the title company, they're going to blame everybody. So we've just kind of made a choice not to do. Yeah. We don't work with investors that do that. So we just, the ones that we know that they put under what they think they're going to sell it for, and then they assign it and it's go, and there's a great closure rate. But I don't know if it necessarily amounts to fraud. I mean, look, if you're, it certainly hits some of the elements. If you're intending to induce somebody into a contract by failing to disclose something like that you're going to drop the price, you might get there. I haven't seen a case where you've gotten there yet, or anybody yet. But I mean, look, again, what's right and wrong is more important to me.
Right. Yeah, I just feel it's extremely deceptive to say, hey, seller, I'll give you 80. I'm just joking. I need 75 or it's a no-go. On every single deal, it just infuriates me.
You might see, I mean, and it's a good point. I mean, you might see some DTPA, which is Deceptive Trade Practices Act. You might see some types of those cases come out. And I think it would take sort of a systematic, I don't think it's going to be a smaller player in the field that's going to get hit with that type of DTPA claim. I think it would be one of the bigger players that, if that's what they're doing, I don't know what they do or they don't do, because I don't work with a lot of them, but it'd be interesting to see what happens.
Yeah.
I think the legislature's really made, in the last 4 to 5 years, has made a very, very conscious effort to protect the consumer, even more than they ever have before.
Yeah.
And when it comes to the advertising and things like that, so it wouldn't surprise me if we see more cases like that. It wouldn't surprise me if we see more changes in the law in the next 5 to 10 years, maybe even in the next 2.
Especially in Texas. I mean, there's a lot of new laws coming out in regards to licensing of wholesalers, whether or not that's going to go through. So, the brokering unlicensed and such. But
yeah, I mean, I don't know what will happen if they actually create a law and pass a law where their wholesalers have to be licensed. I mean, that would be next level. I would be a little bit surprised if they did that, but I wouldn't be shocked.
Right. Yeah. Well, I'm also on a group called the Texas 100, who is trying to protect the rights of the investors and owner financing and wholesalers and stuff. So we're trying to fight that.
Fight the good fight.
Trying, yeah. Well, they do a lot of the work, and we just bring in some money for all the smart people to do what they do. But no. Anyways, so contract, wholesale, disclosures, marketing, protection of those. What about, let's say, because this happened to me several times now. Hey, buyer, let's agree to $135. I need a $5,000 non-refundable, and then we'll sign this assignment. Due to a referral, I didn't require the $5,000 before we signed the assignment. So we had the title, but it takes them a couple of days, and I don't have the 5K yet. I don't have the 5K yet, and then they disappear.
The buyer did.
Yeah. So what are the ramifications then? We've got the sellers thinking they're going to close. I think I'm going to close. Buyer's gone, and I never got my protection of the 5K. Nothing happened of it, but I mean.
Well, I mean, and I don't, I don't know if I've seen your contract or not, but I mean, depending on the way your contract was worded, I mean, your end buyer could be in breach or default of your contract, and to get that 5K, well, I mean, send a demand letter from an attorney to him first, sort of try to push him over the edge just to do what's right. If that fails, then you sue for breach of contract. Usually if it's under for 10 grand, it's in JP court, sue for breach. Now, you've assigned your rights in the contract to the end buyer. Now the seller in turn could turn around, and this is where it's, somewhat problematic. The seller in turn could turn around and sue you. I mean, because you're the one that originally put it under contract. For what it's worth, I haven't seen a whole lot of sellers do that. Usually they're just ready to get on to the next one. But yeah, I mean, that does happen. And that raises another point that I think it's worth addressing is, are you giving your non-refundables to you, or are they going to the title company? I'm a bigger proponent of it going to you, is from the end buyer giving it to you, because then there's less you have to handle and red tape you have to jump through with a title company if you do it that way. But some end buyers are like, no, I'm taking it to the title company and I want the title company to hold it. Okay. Well, that's fine. It just makes it a little bit more complicated to release it should some sort of failure to close like this issue happen. Title companies just tend to be a little reluctant about exposing themselves to any sort of breach of fiduciary duty cause of action, which is really what would result from releasing non-refundable deposit or earnest money to somebody without an agreement of both parties. So title companies are a little reluctant. So if you can get it yourself and the end is okay with it, you should do it that way for sure.
Yeah. I've done it both ways, but I prefer it coming to me anyways. And then we just make sure it's accounted for on the HUD or CD nowadays. But
sure.
Yeah. Okay. Yeah. That was my thought was, all right, I never got my 5,000. Time to go find a new buyer. The only way I'm getting that 5,000 out of them is to go small claims, and it just ain't worth it. So it was just drop order.
It's just not. I mean, if anybody's, I don't know, for all those on the podcast, if anybody here's ever litigated or tried to take a case in JP court, a lot of them are, and I mean this with all due respect, but a lot of them are cattle calls. You go down there to your trial on Monday, and you're kind of waiting around until you get called, and it may 4 days or 5 days. You may get lucky. It may be the first day. You may be in a JP court. You can actually get your trial time. But for a lot of investors, it's just not worth the time. I mean, time is money for all of us, right? So, spending a week trying to get 5,000 when you can maybe go put it under contract again and assign it and maybe get that 5 back. And that seems to make a little more sense to me.
Yep. Same here. Okay. What have I dealt with lately? Trying to get some expert opinion on things that I've dealt with.
I mean, that I think we could talk about questions to ask, for investors that are meeting with sellers, kind of questions to ask to maybe fend off any sort of delay in closing, title issues, those types of things. I mean, if I'm an investor and I'm putting a property under contract, I mean, the first thing I'm going to do before other than running my numbers, I'm gonna check that appraisal district's website. I'm gonna look and see who's shown. If it's John Smith, right, and the appraisal district website's not always right, but let's say it's John Smith, and I go meet, and it's Steve Smith. You're going, where the hell's John? And you find out, and so you need to ask the questions when you go in these meetings. Okay, I noticed it was John on the appraisal district. Hey, is John okay? Is he around? Because he's the one that I want to sign my contract. And then Steve tells you, no, actually, John's my father. He passed away. Right? You got to ask the right questions. Was there a probate? Was there a will that was probated? Or an estate that was administered? Did you admit the will to probate? Well, no, he didn't have a will. Okay, well, let's get started, because now our next plan is going to be an affidavit of heirship, and that's really going to be the only way that we can get closed. So, same with divorce. It's John and Jane, and you go and it's just John, and you ask where Jane is, and he's like, well, we're in the middle of a divorce, but she said I can have everything, and so you don't get to sign the contract, and divorce is not final. Then Jane doesn't have to come to closing. So, those are things that, as far as due diligence is concerned, that need to be done on the front end, because if you've got an affidavit of heirship, and so if there's any other attorneys at other title companies, I know you got there's some we got some mutual connections that are other attorneys at other title companies. We've seen these issues all the time where,
Yep.
you get an affidavit of heirship and they're not necessarily hard to do, but, you're certainly not closing in a day or two, if we pull title and find out that somebody's passed away. So, ask these questions up front and then prepare your title company with what they need to do, or the title company attorney with what he needs to do, so you can get your quick close.
And on probate, hardly ever is it one person as the heir. And I've had it happen several times where I don't have any brothers and sisters, and then it comes down to they've got 4 of them. It's like, holy crap, you guys are shady.
The most I've ever had on an heirship was 28. The guy had the guy had 28 kids with 7 different women.
Holy smokes! So they all got $1.
Yeah, and they were fighting over the pennies, we ended up getting all 28 to sign. One of them was in Leavenworth, not exactly a minimum security prison. So we ended up getting it closed, but that we didn't know about it up front. And that's another thing, you got to think about, like you were saying, you got to think about is, if there's 4 kids that are heirs and you get 3 of the kids to sign the contract and not the 4th, well, number 4 doesn't have to comply with anything. So your only option is to really file a partition action and try to get that 4th kid that's not willing to cooperate, try to get his interest excluded is really what you do, and allow the property to be sold. Right. And those take a little bit of time. So
I've heard of people doing that. They'll buy, if it's 2 heirs, they'll buy 50% of the property and they'll try to work out the details with the other half over time.
Yeah, I mean, to be honest, I get a lot of investors call me about that. Can't insure. Essentially, you can't insure fractional interest, right? So they would be buying it without title insurance. If you can only get 50%, so the investor will go in, buy it without title insurance, and then attempt to work it out with the other 1 or the other 2, or how many other heirs there are.
Yeah, they
can't grease the wheels and get them to sign. Then you could file this sort of motion to quiet title and partition action. I'm not trying to pitch title insurance, but it's worth its weight in gold. I mean, the risk of a title claim is not very high. I mean, it's pretty low in Texas, but you don't want to be that person that doesn't have it,
right?
Especially when you're dealing with heirs, and those are the ones that tend to file a predominant number of title claims. Are heirs or spouses that are pissed that their husband or wife sold the property and they didn't join in the conveyance.
Right. Interesting. Well, for as far as the divorce goes, it can't be done and sold without the decree stating those items, correct?
Yeah, I mean, for the most part, I mean, if you can have a pending divorce, and as long as both spouses join in the conveyance or the deed, you can do it. But if there's going to be some sort of, husband's going to be awarded the property in the divorce, then it would behoove the husband to wait till that decree is final. File the certified copy of the decree, have it serve as a muniment of title, divest that other spouse, and then sell the property. That way he doesn't have to go try to get a disbursement agreement signed with the wife. Because if if he thinks he's going to get it, if the divorce is pending and he wants to get all the proceeds, because he thinks he's ultimately going to get it, well, then the spouses have to agree to the disbursement of those proceeds. And if you can't get that wife to agree or that husband to agree, then you might as well just wait till the divorce is final, and then you get the property and then move on and get your 100% of your money.
Right. I envision that being pretty difficult. Yeah, sure, honey, you can have the house, you can have all the proceeds. What could it possibly be? 12,000, and then they got to sign a document saying 24,000.
Yeah,
pretty hard to get to fly. Yeah.
Yes, it can be pretty difficult, and it's usually really awkward at the closing table too.
Oh, right, because she's still got to be there.
Yeah,
that's annoying. Okay. As far as, because I'm also a realtor, what type of things should realtors be looking out for? Because the broker should be covering their assets, quote unquote, on their end for the most part, but is there something outside of what the broker can protect that a realtor should be looking out for?
And we're talking about outside wholesaling. We're talking about if an agent acting as a wholesaler.
Just wholesaling all to the side. So realtor, acting as a realtor, brokering deals underneath the brokerage, or transacting as an associate of the broker.
Yeah. The things you need to make, obviously you need to look out for. I mean, other than, and I'll just talk about liability. I mean, obviously technology and marketing backing, things like that from your broker are important.
Yeah.
Most of our business, a lot of our businesses are real estate agents, so we love them.
Yeah.
But making sure that there's adequate insurance. Who's covering the E&O? Is it your broker or is it you? Or is the broker covering it? I mean, and then ask the questions. What's the policy limit amount, right? So if you've got a $1 million or $500,000 per occurrence, or your broker has that rather for on the E&O policy, but you're dealing with $5 million deals. Well, the $500 is 500 grand is not going to do you any good.
Right.
Other than, if, God forbid you get sued and then you get a judgment and you get hit for, $5 million. Well, unless you have an umbrella policy, anything over 500 grand, you're paying if there is coverage. So, agents and license holders need to ask those questions and look at those policies.
Yeah.
I mean, and see what it is. I mean, see if they can get a copy of the E&O policy, see what types of things are excluded, make sure there's no funky exclusions in the E&O policy that would preclude them from covering the agent or the license holder. You've got to, that to me is the most important for an agent to do. The broker should also, I believe, help them. You've got to be a resource. I mean, I'm happy to be a resource. We answer calls all the time. I mean, on the agent side. So, and some will call me and say, my broker, I can't get a hold of my broker. It's been 5 days.
Yeah, it's annoying.
Question. It's like, okay, let's work through it.
Yeah.
But have that resource there that you can ask those types of questions to, particularly on the advertising side. As a license holder, if you have a Facebook page, that is predominantly your business, even though it's your personal page, you need to make sure that you put the appropriate disclosure requirements that you're required to do under the law on your Facebook page. Even though there's a social media exception on there, if your personal Facebook page is all business, you need to have the consumer protection notice disclosure.
Yeah. Right.
And those are the types of things that you can go ask your broker, and make sure that your broker's okay with any ads that you're doing. Make sure your ads are in compliance. Because if they're, and I'll tell you one thing, I mean, Trek has been pretty aggressive in the last year to year and a half, about advertising and about agents practicing law.
Right.
And by that, I mean, inserting language into contracts that, is already covered by a promulgated form, or inserting language in a contract that has some sort of legal consequence, which is practicing law. So those are the types of things you just have to be. And let me just give you a prime example. If seller does not accept offer by 5 p.m. on Friday, this offer is null and void. Right?
Yeah.
That language itself, because of the null and void, has a legal consequence. So you can't write that as an agent. Now, I'm not saying that Trek's going to come down and find you and penalize you. This usually only comes up in bad transactions. But
right.
If you want to write it, just say if this offer must be accepted by 5 p.m. on Friday. Just leave off the null and void part. Then there's no legal consequence that you're adding, and you're not practicing law. You're just stating a business fact related to the offer. That's all you're doing.
Right.
So, those are the things you got to be careful for as an agent, and have your broker be a resource for you, or make sure your title company is a resource for you. Your title attorney is a resource for you. I mean, they should answer the phone 7 days a week, because you guys work 7 days a week. So I mean, that's always been our approach. So do we, but make sure you get the right information.
Yeah, that's awesome. I can't remember the last email I've got from you, but do you have any classes coming up? Because I know realtors do listen in. Do you have any classes coming up these guys can swing by?
Yeah, I think I've got, a probate class. Just checking my calendar. I think I've got a probate class next week. And then I've got Legal 1 and Legal 2 I'm teaching on November 7th. So it's for tentative locations, the Inwood National Bank down in Dallas, but I'm going to be teaching Legal 1 and Legal 2 that day. So
yeah,
I don't know if I can give out my email if people want to shoot me an email if they're interested in coming.
Yeah.
So
yeah, we can gather the contact information at the end. Yeah. Okay. Well, anything I didn't touch on there? Any?
I'm trying to think both on both sides. The investing.
About the commercial space? Do you transact any or a lot of commercial deals? Or is there anything to look out for there?
Yeah, we do. I mean, we do a decent amount of commercial business. On the commercial transactions, if people ask, what contract should we use? I mean, if the Texas Realtors has a really good commercial contract. I mean, I've got several I've drafted for, but it's pretty good. Or if you're part of the North Texas, NatCar, they've got a really good contract. I think on the commercial side, it's really tailored to the transaction you're in, right? So if you're buying like we close on a lot of quick car dealerships, okay? And so if you're closing a quick car, you need to know what to ask for. You need to know the types of books that you're asking for. Environmental studies, has an environmental study been done?
Yeah.
If you're just closing on a commercial building, and maybe it's a fourplex, which is technically commercial, multifamily, or a eightplex or something like that, ask for the leases, right? You need to make sure that the leases are in there if they're leased out. You need to also always insist on the commercial property condition statement. That should be mandatory, in my opinion, in commercial transactions. It's not required. In residential, you have the seller's disclosure notice. On commercial, there's no corresponding requirement in commercial.
Right.
But as far as whenever I advise buyers, and particularly buyers, if you're not insisting that seller give you a commercial property condition statement, which is essentially the equivalent of a seller's disclosure, just more detail, then you're doing a disservice to your client. There's too much that can go wrong on commercial transactions. I mean, you have toxic waste, you have wetlands, you have all sorts of issues that come up on commercial deals that you don't see on the residential side. We don't commercial leases. We review those for people. Those can be rather specific. I'll tell you, for the most part, a lot of the big developers and owners of these buildings, they don't tweak their leases a whole lot for you. I mean, our lease on our building here that we signed in Plano a few years back, I was insisting on changes, and they basically told me, no, we'll give you a couple.
Right.
So the leases are a little bit different. But on the commercial side, it's just the due diligence requirement is significantly higher. And I'd encourage anybody that's trying to get into commercial on the first one to go talk to a real estate attorney or a commercial broker that's been doing it a while, to ask those questions. Again, when was the last environmental study that you did? Do we need any estoppels? Can you give us all your UCC financing statements? I mean, those types of things that come up on commercial need to be asked for.
Yeah. Well, that's an interesting point too, because I just wrote a commercial contract for a buyer. I didn't check, or I checked the box that said no UCC filing documentation to be that then was needed. And then I required estoppels, but then the agent just called me back actually just minutes before we jumped on this. And he was like, I mean, we can provide them. It's kind of a pain in the butt. Most people just write new leases. Obviously you can't tear up a lease and kick them out. So you have to keep that lease. And so an estoppel is going to verify that time frame. Would you recommend that 100% of the time those estoppels are?
Estoppels they're really, really important in my mind. I mean, there are times where, a lot of it's circumstance. I mean, what are the circumstances? I mean, if you, like in your situation, if you're talking to this guy, or maybe you've already had contact with some of these tenants that are in there, and they're willing to, you can already tell that there's sort of this good relationship going on, and you might be able to just get those renewed. It's not going to be a problem. Well, then you may not require them, but I put it in the contract though, right? Because if you put it in like you did, you did it the right way. I mean, you put it in the contract, because if the seller can't provide it, buyer's not in default. The seller's failed to comply with the contractual provision, right? So, it's just another way that the buyer may have some sort of argument down the road. What should they need to get out of the contract? Fail to perform. So put it in there. And if you need to negotiate about it later, you can discuss it later with the other side and do that. But I would always start that way. On the UCC filing, it's not as important in the sense that title searches generally reveal UCCs.
Yeah, that's what I thought too.
Yeah. So whatever, whatever title company you guys or whoever has the contract, they'll, as part of their title search, reveal any UCC filings. So you're going to get copies of those.
Yeah.
So it's not as necessary to put it in the
And
contract.
that's just basically showing that their LLC is in good standing. They're not behind on franchise taxes and all that gibberish.
It's part of that too. And then what you see on a lot of commercial buildings is fixture filings. So you'll have like let's say
restaurant.
Yeah, like a restaurant. You've got the kitchen, right?
Yeah.
You've got these big fixtures that are in the kitchen. Well, a lot of times those aren't bought.
Yeah.
Those are they're either leased or they're loaned. And so in either instance, a UCC gets filed in the property record stating, hey, here's a lien on this personal property, because may not be considered real property. But there's a lien on this. It's like on residential deals where you see solar panels, right? You're going to see a UCC filed in every house that has a solar panel unless it's been paid off. So,
right.
Yeah.
Or, like laundry and apartment complexes. Those are almost always leased in a sort of contract.
Always, like, a brewery, all of the equipment for doing the beer.
Interesting.
But you're going to see UCCs file most of those unless people are paying for them outright.
Yeah.
They took out a commercial line of credit and bought them themselves. But if they didn't, then and that company hasn't been paid off, then you're going to see a UCC on there, and it should be filed of record too, and it'll be filed with the state.
Yeah.
So time will find that.
Okay, that's a good point. And then back to the estoppels. This one's 6 duplexes, so I don't think the estoppels are super important. But let's say like storage, you never know if they're being truthful about storage facilities. If they got 400 little bays, that seller could be utilizing 26 of them and just having it as an income, but never actually paying the company. So you'd have to run an estoppel to clarify who's occupying all 400 units.
Yeah, and you're going to know what exactly you're getting into. Certainly on storage units, those are a big one. Just a regular warehouse. I mean, if there's nobody else that's in there and there's nobody leasing out any space, then it's not really as necessary. But on a facility, for sure, you would do that, and you'd insist on it.
Yeah.
Because I think, we've closed in some storage facilities before, and it just tends to be a little looser.
Yeah.
And there are people, I think, that do exactly what you just said.
Or family.
Or family. I mean, so make sure you get those types of documents on commercial ones you just want to know what you're getting into. I mean, I wouldn't want to spend the kind of money on a storage facility and not really know what I'm getting.
Right. Or who's actually paying and who's been there.
And, you can, you should ask for rent rolls. I mean, things like that on, apartment complexes or multifamily. I mean, you need to get the rent rolls. You need to get a history of their payments, right?
Yeah.
Ask them if they've kept a good track record of when the rent was paid and how often they paid, or were they on time, or did they miss 4 in a row, or do you have the security deposit? Do you have a record of the security deposit? Because all those types of things, if the right records are kept, then the buyer will know what they're getting into. And another thing, they'll be treated for or addressed at closing, which is when they should be addressed.
Right, where all the deposits are transferred over, and
you can't put those on the closing statement if you don't have proof, unless both parties agree. So we'll get people say, well, he gave me, $500 is for his rent. Well, did you ever sign a lease? No, he just was a month-to-month tenant. Did he pay you a deposit? I don't know if he paid me a deposit. Well, I can't give the buyer. I don't know.
Right.
So, those are the types of things in the commercial realm that just need to be addressed.
Yeah. Well, maybe I did a bad job interviewing, but we skipped all over from wholesaling to investing to the realtor world back to commercial. But it was great having you. I appreciate it. I mean, did I miss anything? Do you want to talk anything about any other topics?
The only other thing I thought about is just how you're as an investor and a wholesaler, how you're protecting yourself. Are you in an LLC?
Right. Okay.
What corporate structure is the best corporate structure for you? I mean, I'm a big proponent of the LLC. All my companies are LLCs.
Yeah.
With an S corp tax election, but talk to your CPA, find out what makes the most sense from a tax perspective for you. I would not be wholesaling in your individual names. not a good idea. If you've got a homestead or you've got other investment properties in your personal name, you need to try to get them in an LLC if you can, or you need to carry an umbrella insurance policy. You know, for investors that have rental portfolios, they either need to be in an LLC or you need to have a really, really good umbrella policy.
Yeah. Yeah, that's how. Yeah, so I've got the two LLCs with the S corp, and then actually one's a series LLC for the rental properties now. But what do you think? And I brought up another topic about trust. So I know some people that are uber billionaires. On paper, they own nothing, but they have 300 rental properties. I've talked to super different people. It's like, yeah, be the invisible guy or be the guy that you don't want to be on the judge's, firing board if he sees you have 300 trusts. So what's your input on that?
Yeah, I mean, there are so many types of trust out there that you can create. Personally, I think it's beneficial to have a trust. I mean, I'm talking not for the anonymity reasons, but the Brandon Richards Family Trust, right? I mean, if you've got that for yourself, it just saves your family down the road should something bad happen to you, God forbid.
Yeah.
Probate administration. But the trust standpoint for anonymity and for liability protection, if that's why you're doing it, and putting properties into these trusts. In my opinion, it's always been a tax question, a CPA, what benefits you the most. I think trusts are oversold. I think and trusts are very expensive to create, which is why I think you get a lot of people out there that just push putting all your property in trusts.
Yeah.
But there can be a benefit from a tax perspective if you've got different types of trusts based on how you've set them up. If that's why you're doing it, then I think it's a good idea. If you're just doing a trust for this anonymity and because you don't want to be on somebody's firing squad, I mean, I get that too, but you can really accomplish the same thing with a corporation or an LLC. But I'd encourage all investors to talk to a CPA about whether a trust makes sense. I know one of our absolute best clients, investor client, all of theirs are in a trust, in various trusts, and part of that is anonymity, but a greater part of that is tax.
Yeah,
because they're saving a lot of money in taxes by going through various types of trusts. So,
interesting.
Yeah, I mean, if it makes sense for you for that reason, go ahead and do it. My personal life is set up in a trust so that my wife and my kids don't have to deal with anything should I pass away. And I think that's a good thing to have. From a personal standpoint, professionally, whether it's corporations and things like that or rental properties, talk to your CPA, find out. I mean, there are certain types of trusts that can cost 30, 40, 50 grand to make.
Really?
Yeah. I mean, and these are the types of trust that are extremely complex. There's a very special segment of trust lawyers that do them, but they save you a heck of a lot of money in taxes. But, do you want to spend 30, 40, 50 grand to create this type of trust? They're really big investors that come from California.
Really?
A lot of people come from California. And that's a probate process that nobody wants to go to probate in California. So everything is in a trust.
Yeah.
Everything. So
yeah.
I think it'd be beneficial. I think they just need to talk to their CPA and find out what makes the most sense. And find a good CPA. If you don't have one, if you're getting into investing, you need a good one. Because as you know, Brandon, there are some, and us self-employed folks know we can get taxed pretty good. So we want to have a good CPA on our side.
Yeah. Or if you hate paperwork like me, make sure you got a good accountant because
yeah.
As soon as the Excel sheets come out and QuickBooks come out, I'm lights out. I'm done. I just stopped thinking.
Nope, not happening.
Yeah. Cool. Well, what was your email so we can get this out there for them?
It's Sean, so SEAN at TIAGOTX.com. So Sean at TIAGOTX.com. So if anybody ever has any questions or legal questions, title questions, wants to talk to me about getting into wholesaling, investing, contracts to use, classes they want to come to, just shoot me an email.
Okay. Awesome.
Appreciate you. You're an inspiration to a lot of people out there, so keep doing it.
Thanks, man. Appreciate it. But not quite done. I ask everybody the same question every time. If you had 6 months to live, what would you do with it?
I have a 2.5-month-old and a 10-month-old and a beautiful wife.
Wow.
Would take a significant amount of time and travel with those 3 other people that I love dearly, and take them everywhere they wanted to go. I love my business, but family is family. So, and I would travel. I think travel is important.
Yeah, it's a big, big world out there, and just seeing it gets you a different perspective. I think it helps you grow, not only in your heart but in your mind. And so I love traveling and family, so I do my best to integrate them both as well.
There's a lot of people that have a lot less than we do. We're all pretty fortunate, so it's nice to give back to those that need it more than we do.
Yeah, and then you realize that your problems are tiny.
Yeah. I dropped my water on me on the way to work this morning, and I realized after a second or two of complaining that wasn't that big of a deal.
Right.
People don't have water.
Yeah, the water will dry, but somebody else needs to drink it. Right. Yeah.
Right.
Cool. Well, I appreciate it. Thanks for coming on.
Anytime. We'll talk soon.
All right. Cool. We'll catch you later.